Is abandonment a valid reason for divorce? Imagine a marriage where one person suddenly leaves without warning or explanation. Could that be enough to end the marriage legally? Well, in many places it can be. Abandonment, also called desertion, is recognized as a valid reason for divorce in several jurisdictions. But it's not just about leaving, it's about the reasons and the way it's done. In family law, abandonment means one spouse leaves the marital home without the other's consent and without a good reason. It also involves the intent to end the marriage. This is different from both spouses agreeing to live apart. For abandonment to count legally, certain rules usually apply. The separation must be voluntary, without mutual agreement, and often must last for a specific period, usually 1 year. Not every departure qualifies as abandonment. If a spouse leaves because of abuse or domestic violence, courts generally do not see that as abandonment. Instead, they might see it as a response to dangerous or harmful conditions. Sometimes, if one spouse's behavior makes it impossible to stay together, like refusing to support the family or engaging in harmful actions, the court might treat the situation as constructive abandonment. This means the court considers the staying spouse as having effectively abandoned the marriage because of the other spouse's actions. Proving abandonment in court involves showing evidence. This can include documentation that the spouse moved out, records of communication indicating the intent to end the marriage, witness statements, or proof that the spouse stopped providing financial support. The person claiming abandonment has to show that the separation was intentional and justified and lasted long enough to meet the legal requirements. Filing for divorce based on abandonment can influence the case. In some states, proving abandonment might help you keep the marital home or get better terms in dividing property. If children are involved, abandonment can also impact custody decisions, especially if one parent has stopped participating in the child's life. It's important to check local laws because rules about abandonment as a reason for divorce differ from place to place. Some states only allow no-fault divorces, where you don't need to prove any fault like abandonment. Others allow fault-based divorces, where abandonment is one of the grounds you can use. In summary, abandonment can be a valid reason for divorce in many areas, but it has to meet specific legal definitions and be properly proven. The process and what you can gain from it depend on where you live and your particular situation. Always talk to a family law attorney to understand how these rules apply to your case and what steps you should take.